Little sign up here because this is what I'm going to talk about today. I have a lot of things on my mind. It's a crazy year. I'm so sorry we're having all this chaos around us. I am outside. There's a little bit of wind blowing, so you can hear my chimes in the background. A bit peaceful and centering for me. I love the sound of the breeze and of the chimes, so hope they don't bother you. All right, so it is close to Thanksgiving. I'm sure a lot of you are going, I'm not sure what we have to be thankful for this year, but, you know, God love us. He's going to see us through this, I'm sure. So just keep praying, keep praying. All right, so a few of you will share that. This is what I want to talk about, incarcerated kids and forced adoption. And I hope you can hear me. I'm going to turn this around now and we're going to get set up. Okay, so, hey Brian, good afternoon, Wendy, Allison, hey y'all. So, Jeff, good to see you. I want to talk today about incarcerated kids, and the reason it's come on my mind today is because I have worked really, really hard trying to protect incarcerated children, and I will say one in particular incarcerated child for the last 7 years. And we just received the, hey Brian, hey Heidi, we just received the ultimate kick in the shins from the United States Supreme Court, where our writ of certiorari was rejected on qualified immunity. So this covers a discussion about kids in jail, what people do to kids in jail, why we don't do anything about it, and also I'm going to tie that into forced adoption. It is a pretty, both of those are pretty broad topics, but let me just tell you, I'm going to talk about kids in jail and solitary confinement. All right, so in 2010, there was a young man in the Bronx. His name was Khalif Browder. We don't hear that name anymore. We don't really think about who he is. He's not famous. He doesn't have a statute. There are no riots over him, which there probably should have been. But Khalif Browder was a young black man, and he had stolen a backpack, or allegedly stolen a backpack. And he ended up in the juvenile system in New York, and they put him in Rikers, and they put him in solitary confinement. And he was, as a young man, who was a young teenager, was left in solitary confinement for 2 years without even having a guilty against him. So the first thing I want you to understand is that if you are incarcerated, and it's not a sentence, in other words, you've not pled guilty, you've not been found guilty, you are incarcerated as what's called a pretrial detainee. When you are a pretrial detainee, you have a right to be free from punishment because you've not been convicted of anything. You are not incarcerated because you're being punished. You're incarcerated because either they feel, it's a matter of not being able to make bond, or they've set your bond conditions too high, or they feel this quote-unquote threat to society, or that you'll flee. So Khalif had a very, very difficult life, and he ended up being incarcerated as a pretrial detainee, and nobody was either smart enough or brave enough or knew enough to be able to get him out pending an actual trial on this petty theft, basically. So in about 2013, Khalif was released, and in 2015, he committed suicide. So in 2018, yes, there is a movie about it on Netflix, thank you. So in 2018, Barack Obama entered an executive order banning solitary confinement for juveniles in federal prisons. Now remember, that's only federal. He cannot do anything about state courts. He can't do anything about DCS. He can't do anything about kids in foster care. He was only able to ban solitary confinement for juveniles as to prison. Now, this was not the first time that the issue had come up. The United Nations had already issued a statement that to put a child in solitary confinement for more than 24 hours was torture. The ACLU in 2012 had published a very extensive, well-documented paper called Alone and Afraid, and it talked about how a child being in solitary confinement for more than 24 hours was torture. And yet, in 2003, I'm sorry, I got to go back. Also, from a state level, we had PREA. So PREA is the Prison Rape Elimination Act, which was originally passed by Congress in 2003. It was adopted by the state of Tennessee shortly thereafter. And also the Department of Children's Services had a policy against segregating children for punitive reasons. With all of those things in place, in spite of all of those things, in 2013 in Williamson County, under the direction of juvenile court judge, Williamson County, Sharon Guffee, a young man was incarcerated as a pre-trial detainee and put in solitary confinement because of an alleged threat that he'd made against another child in the dorm. Okay, now there are 3 children. 4 children fit into a dorm room. Allegedly, he had made a threat. The next day, all 3 other children left the facility, but in spite of the fact that he was a pretrial detainee, he never had a hearing as to whether or not this threat had happened, whether or not he had ever been any harm to anybody, and in spite of the fact that the other 3 children had left and actually later recanted their story, he was left in solitary confinement. And this wasn't just an ordinary young man. This young man had a brain disease. I mean, it's a brain disease. And there is a brain disease called PANDAS, pediatric autoimmune neuropsychiatric disease associated with strep. Okay, so there are a lot of families out there. There are now Facebook groups that understand that there is such a disease. It's when an infection gets in your body and your body can't fight it. It's basically an autoimmune disease, just like lupus and MS and arthritis. It's an autoimmune disease in your brain. And when children have strep throat as a child, what can happen is the body does not completely get rid of it, and there is a creation of autoantibodies, and those autoantibodies begin to attack your body. And that's what happens with, it is, Williamson County is a mess, Lucas, thank you. So autoantibodies attack your body. Again, this is the same thing that happens in lupus and MS and cancer and arthritis, and it goes on and on. But for children, this is critical. It's called PANDAS, pediatric autoimmune neuropsychiatric disorder associated with strep. And there is also PANS, P-A-N-S, pediatric autoimmune neuropsychiatric syndrome. This was a young man who suffered from an autoimmune disease in his brain. And he had, when he would be exposed to infection, his body would create autoantibodies. They would attack his brain. It affects the neurotransmissions in the brain, and they have a variety of manifestations. It can be OCD, it can be paranoia, it can be tics, it can be the inability to speak, it can be the inability to write, okay? But it's a disease. And this child, who they knowingly had PANDAS, the juvenile court, Judge Guffee had been told he had PANDAS, and she put him in solitary confinement. And in fact, when the mother tried to get him in a neuropsychiatric center, Judge Guffee said she didn't want to hear anything else about PANDAS. And when the mother took him to another state, and they were having problems getting the insurance approved, she was trying to get him into a facility in Illinois, and Judge Guffee found out that he had not been immediately admitted to the facility. She said that the mother had to bring him back to Williamson County, Franklin, Tennessee, and lock him up, where she put him in solitary confinement, as opposed to having medical treatment. This young man spent 51 days in solitary confinement. After we were finally able to figure out what had happened to him, we realized that during this course of time, and he was able to articulate some of the things that happened to him during that time, it was torment. It was torment, okay, where he would beat on the walls and scream, and he would cry out. He would talk to himself. He had bloody fists one time. He would stand on his head. He would clang on the bars. I mean, just all these things that were occurring. He was cut off from his parents. He wasn't even able to talk to his parents. Judge Guffee cut him off from even having a conversation with his parents. Judge Guffee cut off from his parents from even visiting him or talking to him. And he was assaulted by a staff member while he was there. Yes, yes, Suzanne, I totally agree about forced adoption. I want to be able to talk about that some more too. But this young man was totally cut off from his parents. The only people who could see him was, guess what? The guardian ad litem, who spent about 20 minutes with him, right? And then he did get out for a short break to go to a psychiatrist, and who was struggling to be able to give him some type of medical diagnosis that would get him some help, but they were unable to do so. This family came to me after the fact, and we began a civil rights litigation. There were things that happened to him in the facility in which he was assaulted, and guess what? There was video evidence, and they destroyed the video evidence. When the case finally came to the district attorney's office, and the district attorney had other hard evidence about what had happened to him, and the child explained what had happened to him, the district attorney improperly charged the employee or gave the wrong charge to the employee at the facility, and he walked away scot-free. So we tried to get civil rights relief for the child, and here's what happened. So 2 things: the solitary confinement, actually 3 things: the assault, the solitary confinement, and the lack of medical and mental health treatment while at the facility. And we took that to district court, and then we took it to 6th Circuit Court. The district court dismissed it, finding that there was no clearly established right for a child not to be held in solitary confinement. All right, so if you've seen issues of qualified immunity come up, you know that you have to meet 2 criteria to have a civil rights case. You have to find a constitutional violation, and then you have to find that that right was clearly established. Now, that clearly established criteria, what that has morphed into is that you have to find another case in your circuit that's exactly the same set of facts. Okay, so my circuit is Tennessee, Kentucky, Ohio, and Michigan. 4 pretty conservative states, actually, although Ohio tends to be more liberal, and Michigan sometimes, but they're fairly conservative. But you have to find that there's some other case that some other person has brought this up and has established that right. So you've got to understand what this means, that technically you have to throw a plaintiff under the bus, okay? There has to be a plaintiff that takes the fall before the right can be established. And I want you to think about how backwards that is, okay? So our rights are established by our United States Constitution and the the Bill of Rights, right? Our rights for freedom of speech, our rights to own weapons, our rights to be, our 14th Amendment rights are the ones that we use in state court, cases regarding things like this, right? Because it's not really a 6th Amendment. It's all under the 14th Amendment, due process, substantive and procedural due process rights. I mean, our rights are established under the Bill of Rights, and yet until you have a plaintiff that's willing to take the fall and get an attorney who will sell their soul to be able to research it and write it and spend hours and hours and hours and hours and hours and hours and hours writing briefs, then we don't have any rights. We don't have any rights. So the district court dismissed the case and said that there was no clearly established right that a juvenile could not be put in solitary confinement. Now, I want to also tell you what happened in Tennessee. In Tennessee, 2 years in a row, one state rep, Mr. Hardaway, I think he's from West Tennessee. He's a Democrat, African-American representative, but a very nice guy. And he, and I didn't mean to say it that way, but excuse me, no offense to anybody. I'm so politically nervous these days about anything I say, so just bear with me if I make a little screw up here, because you know where I'm going with this. Anyway, Mr. Hardaway presented 2 times that juveniles would not be put in solitary confinement, and it would not pass. And let me tell you why it would not pass. It would not pass because the Department of Children's Services went in and said it would be way too costly for them to shut down solitary confinement for juveniles, okay? So this is in spite of the fact that we have a federal executive order, in spite of the fact that we have an ACLU extensive white paper on it, that we also have the United Nations doing a general statement about torture of young children who are put in solitary confinement. There are other old cases, the United States Supreme Court case, there's an In re Medley case, that really just talked about how horrific and torturous solitary confinement was, and yet Tennessee would not pass a law to ban solitary confinement of juveniles. So the district court said there was no clearly established right. Now, as to the medical treatment, the district court said, well, they had the ability to rely on the psychiatrist that saw him that said he was getting better. Well, here's the problem. The problem is that the only information that the psychiatrist had is what this poor child told her on December the 6th, okay? She didn't have any reports from staff. She didn't have any juvenile court records to see how he had been treated or to see how he was reacting, okay? So, I mean, if a parent takes their child to the doctor, what does the doctor do? The doctor turns to the parent and says, what have you observed? What's going on? You don't rely solely on a 13-year-old child. And so the psychiatrist didn't have the proper information. In spite of the fact that I brought it up, that they didn't have good information upon which to make a diagnosis, the district court found that they could rely on the psychiatrist's visit on one day. The other issue had to do with being assaulted, and basically they found that the juvenile court detention center had no way to anticipate that this child could have been assaulted while they were in their facility. They had no reason to believe that their training was insufficient or that their hiring procedures were insufficient, so therefore the county has no liability. No liability. Yeah, that's exactly right, Brian. They've denied my writ. I'm going to go on. So I go to the 6th Circuit Court, write lots of briefs. Oh, and let me tell you, with the 6th Circuit, I even had an amicus. I had an amicus brief filed by an association of child psychiatrists and psychologists who said that putting a child in solitary confinement is torture, and we've known it a long time. So I go to the 6th Circuit Court. And here's the important thing. Now listen carefully. There's an old United States Supreme Court called Hope v. Pelzer, P-E-L-Z-E-R. You can look it up. And Hope v. Pelzer was a case where, it's a gruesome case, but this young man was tied to a hitching post, I think, by law enforcement, and they left him there, and it was just horrible. I mean, they treated him horrible. In this case, he went for a civil rights case, and again, they found there was no clearly established right to show that being tied to a hitching post was torturous, right? Or cruel and unusual punishment is what they call it, which is really torture. So they dismissed it, and it goes to the U.S. Supreme Court, and the U.S. Supreme Court, for once, I'll have to get the justices for you so you know who wrote this brilliant opinion, because they said in this United States Supreme Court that you don't have to have a case on point. There doesn't have to be a case with the exact set of circumstances. When there is enough information out there to put the state actors on notice that their behavior is unconstitutional, then you survive qualified immunity. And that's what I argued. I argued there was plenty of information in 2013 for Judge Sharon Guffee and her employees, Steve McMahon and Betsy Agent, to know that putting this child in solitary confinement for 51 days was torturous. There was plenty of information. There was PREA, there was the ACLU, there was the United Nations, there was all kinds of other publications. There was In Re Medley, the old United States Supreme Court that talked about how torturous solitary confinement was. And I said, you can't, if we're going to have qualified immunity, then we need to have the ability to hold state actors. Now, state actors, if you're not familiar with civil rights, are government workers, okay? We have to be able to hold government workers to their heels when there is ample information to know that something's wrong. I mean, to know that something's wrong. I mean, what would it take? What would it take for a person with 25 years experience in juvenile detention to know that putting a 13-year-old with a mental health disease in solitary confinement for 51 days was wrong and cutting them off from their parents? What would it take? What would it take? And so the Sixth Circuit came back and said, we agree that this could have been punitive and that this could be a violation of, this is a violation of his constitutional rights. The Sixth Circuit said it is a violation of his constitutional rights. But they said in 2013, it wasn't. It wasn't. So this young plaintiff, who now will suffer for the rest of his life from PTSD, from attachment disorder, from anxiety, depression, flares. This young man will suffer all of his life because nobody in 2013, nobody knew that it was wrong to put a juvenile, a 13-year-old child who had a mental health disorder in solitary confinement. I sent it to the Supreme Court, and they just rejected it. They just rejected it. I was hopeful, and although rarely does anybody get into the United States Supreme Court, rarely. And so they rejected it, and I was a little shocked because I had found within the past 12 months 2 cases. Both were rejected by the Supreme Court, but there were some pretty extensive opinions written. One was by Justice Sotomayor, and one was by Justice Thomas, where they said we really need to seriously look at qualified immunity and what it takes, how we're examining that. And so I was hopeful. I spent hours and hours and hours on a brief. We spent thousands of dollars on getting it, published in the little booklet form. I mean, I've put out of pocket thousands of dollars to do depositions and try to get this issue properly examined, and they rejected it. And that's why I said in my post the other day, civil rights are dead. Civil rights are dead. 42 U.S.C. 1983 is worthless. It's worthless. It's worthless. So all you parents out there who are being abused by the system, take a deep breath, because all of you go, I want to go to federal court, It's almost impossible. Out of civil rights cases, 90% of them get dismissed. But let me tell you, on the other hand, the only way, right now, the only way we have to carve out our civil rights are to either force a change in the laws, force a change in the laws, and they have to be crystal clear, or bring more civil rights cases. Find attorneys who will buckle down and write some briefs on it. Find plaintiffs who are willing to be thrown under the bus, because until we can get clearly established rights, we have no rights. We have no rights. The Bill of Rights means nothing until you have a plaintiff who will be thrown under the bus. So the next plaintiff child who's in solitary confinement, will they get some relief? Maybe they will. But my client will suffer damage forever, psychological damage of solitary confinement forever, forever, with no relief, no relief. So I want to tell you how likewise my position is the same thing that I believe occurs with forced adoption. Children who are taken out of the home without exigent circumstances, without a need for immediate protection, are incarcerated children. They're incarcerated children. They have been given, they are put into a situation, a stranger's home that they don't know, that they have, a new set of restrictions, cut off from their family. I mean, it's incarceration. There's no other way to look at it. There are very few civil rights cases brought in behalf of the children. There are very few. There are very few. So, so I tell you, we have to have cases brought in behalf of children. I don't know who's going to do it. It's almost broke my back. It's worn me out. They're very difficult. It takes a lot of time, a lot of money, a lot of resources. It's a lot of frustration, but I don't know what else, unless we can create our rights legislatively. And that means y'all need to get on your state legislators. So hard to do, guys, but there's no other way to save our civil rights. And they have gun rights up there, they have abortion rights up there, family rights and children's rights, family integrity rights are essential. Our nation has twisted and violated us for 6 decades. Ever since 1974, with CAPTA and the Mondale Act, when they started flushing our Social Security money into the states for the purposes of child welfare, it has become worse and worse and worse. Layers and layers and layers of laws. Layers of laws. I mean, every 3 years there's a new law related to foster care and foster care money. So it becomes almost incomprehensible to even try to understand it. 20 years later, 1997, the Adoption and Safe Families Act put a price tag on every child's head. At the time, it was $4,000 and $6,000. When it was reauthorized in 2010, I believe, it was $10,000 and $12,000. Each child has a price tag on their head to become socially engineered into a new family. I have not seen things get any better. I've not seen things get any better. It has gotten worse. It is worse. It is worse. I don't know how to tell you. I hope you will share this. I did this in the Family Forward Project because we have 15,000 here. My page, I have 5,000, and it's more my personal and my personal political views. But the purpose of the Family Forward Project is to really educate and to put news out there about where we are as far as family rights. It doesn't matter. It's a bipartisan issue. I don't care where you are politically. These are matters that have been bastardized by both Republicans and Democrats. In 2001, yes, you're right, it's money. In 2001, George W. Bush and Tony Blair, kind of secretly, I have found it, I don't know if I still have it, but they sort of secretly proffered a white paper on forced adoption where it was their intent and they were going to promote whatever it took to move kids through the child welfare system and rehome them. Okay, that's a Republican thing. Let me also tell you, George W. Bush was the governor of Texas, and he was the first governor to privatize welfare. And who did he privatize welfare with? Lockheed Martin. And who is associated with Lockheed Martin? Lynn Cheney. And who is Lynn Cheney married to? Dick Cheney. Okay? So once that privatization started, foster care became a for-profit business. For-profit. Okay? Foster care is for-profit. In 2011, I started banging chains against the bars, saying that Governor Haslam in Tennessee had appointed Jim Henry as the commissioner of the Department of Children's Services at the same time that Jim Henry was the CEO of Omni, which had a $53 million contract with the Department of Children's Services at the very same time he served as commissioner. So now what we have is we have inherent conflicts of interest between the contractors because they provide foster care and they provide quote-unquote reunification services. And I always say you can't have your little fingers in both pockets. You can't have your fingers in the foster care pocket where you get $130, $40, $50, $100 a day and have your fingers in the reunification pocket where maybe you get $30 or $40 a month. We have to go to our state legislatures. We have to forbid that conflict of interest. So if you want rights, and I'm going to close with a recent post I did today. I did a post today, and I know Luke is on here. I saw him just a second ago. So I had a dad that I had help him work on his case. I had him file, pro se, a civil rights case. I thought it was pretty clear. The judge, not the judge herself, but the judge's clerk, signed an ex parte order for the removal of a child and to put the child in, that's okay, Cindy, you can go back and watch it, the whole thing from the beginning. Yeah, no legislator will stand. Anyway. So in Hickman County, Tennessee, Judge Amy Puckett had allowed her clerk to sign an ex parte order for removal of the child, and there wasn't even a petition filed. And instead of contacting the dad or instead of trying to figure out how safety could be addressed if there was a safety issue, the Department of Children's Services swept in, took the child, put him in a foster home, then put him in a relative placement, and they ignored the non-offending parent. So I had him file a pro se civil rights case, keeping it very simple, and saying that the ex parte order was a violation of substantive and procedural due process, and that it was an administrative role of the judge to allow the clerk to sign the order. I thought it was perfectly clear cut. So Judge Campbell in the federal district court in the Middle District of Tennessee dismissed it. And he said, there's, in Tennessee, now I think he went back to a 1964 case in Tennessee, and I'm going to look it up because I don't think it applies. But he said in this 1964 case that the judge could adopt somebody else signing their name. That's what they said. I don't think it applies, but I'm going to verify that. Here's the other interesting thing he said. He said that the Rooker-Feldman doctrine prevented a parent from seeking civil rights relief for procedural and substantive due process rights under a ex parte order. And he quoted the Vanderkood case, which is a Sixth Circuit case that came out in early 2019, which actually was very clear that the purpose of the Vanderkood case was to limit the use of the Rooker-Feldman doctrine because the district courts were using it to clear their dockets. But then he also quoted 2 of my cases where I challenged ex parte orders, and they are on appeal, but I challenged the procedural and substantive due process rights under ex parte orders, and this very same judge dismissed them using Rooker-Feldman, and now in this third case, he's using it to dismiss again and naming my cases. So don't tell me there's no discussions behind the scenes, okay? Oh gosh, Connie, you're suggesting that the judges maybe talk to each other, or somebody sent him a message or an email, or are you suggesting that somehow he knows that you're involved when your name wasn't even on the case? I'll let you guess that, okay? I'm gonna let you try to guess that. All right, so I'm going to say goodbye because I don't like my videos to be too long, because I like to upload them to YouTube and keep them in a reasonable manner and a reasonable upload. So thank you all for joining. If you missed part of this, please, I will post it. Please go back and watch the whole thing. It really helps you understand about how I feel about solitary confinement and how I feel about forced foster care and adoption. And I have also, I think I'm just going to prepare it separately. I've done a little outline about elections and what you need to know about elections. There's so much craziness going on right now, and just to help you understand how things could go wrong. So if you want to see that, keep watching. I may post that on my personal page because, as I said, I try to keep family forward more about child welfare and child welfare reform. But keep watching because I will probably be posting that soon as well. So like I said, if you've just come on, please go back, please watch the whole video, and share this video. Share this. I love you all. Thank you all so much for being advocates and being strong and not stopping. My heart breaks for you. I know how many of you are grandparents who've lost grandchildren, and there's just so many wrong things. The only way we can save our nation is if we continue to work together. All right, so goodbye. I love you. Please have a good Thanksgiving, and be thankful that we have each other. All right, I'll see you. Bye-bye.